Hello, friends. My name is Chinmay Naik, and I'm here to talk about questionable dealings from this society, Sukhi, Jeevan, Dombivli East. I'm making this disclosure with the awareness that a lot of societies and their managing committees are currently acting in a capacity which is not permitted or authorized to them under the Maharashtra Cooperative Societies Act. This is in relation to a redevelopment project that is currently being planned and how the society has been obstructing our rights to participate as a member of the society in that process. To proceed with this disclosure, I would like to just start with a few basic facts. My father has been living in this flat since 1971. He had a share transfer from my grandfather to my father in 2001, and my grandfather passed away in 2005. Upon my grandfather's expiry, the society chose various means to question my father's membership of the society and denied him benefits such as attending AGMs, SGMs, or causing all kinds of obstructions in his active participation as a member. These issues were resolved when we obtained an order under Section 22(2) from the Deputy Register of Cooperative Societies, who ordered that my father's membership that was granted in 2001 via share transfer was valid and it should be continued. This happened, and the society ingested it in their formal records that my father was considered a member. This was in 2016. At that time and prior to that, my father also submitted a no objection certificate from other NOCs, from other legal heirs, stating that they have no objection to the share transfer that occurred in the past. And my father also lodged an indemnity bond with the society, stating that he bears full responsibility regarding any legal disputes or conflicts that might arise out of the ownership of this flat. Now, despite possessing so many official formal documents, a lot of them are notarized, the society still chooses to question my father's ownership of the flat. And we believe that this is a gross misunderstanding, misconception on the society's part of what powers they have as the office bearers of the society. Well, this is because the society has a default position that has been uncontested for almost 17 years now, and they have been indemnified of any potential legal challenges that might arise in future. In that sense, I don't understand, or I wish to question the society on the grounds that they are using to question the ownership of the flat, especially when there is no dispute arising between the legal heirs or any potential claimants. At this point, and for the past 15 plus years, my father has been the claimant. We have had uninterrupted possession of this flat. We've been paying the maintenance bills, and we have also, uh, my father has also appeared on the as the owner on the utility bills. So, under these circumstances, I cannot fathom as to why the society would still dig up old issues and question my father's membership that was granted in 2001 to the society, and that made him the de facto owner of the flat since there were no legal challenges presented after a certain time since obtaining those NOCs. So clearly there is also the doctrine of estoppel, which for our viewers means that if any disputant or party has acted on a previous event, then it cannot question the validity of the same. In this case, the society, its managing committee in 2001, acted and admitted my father as the member, and as such, after these many years, they are not in a position to question the validity of the same, because The legal system also has a statute of limitations, which means that they cannot entertain disputes about things that are well settled in the past. So, as such, I am here to question the society on its dealings with us, especially in relation to the ownership of the flat, the uncontested ownership of the flat at this point, and their motives for potentially excluding us from the redevelopment process. Because I clearly heard them saying that they will not issue NOCs to sign developer agreements with the builder to those who are unable to prove their ownership. Well, firstly, I don't feel like the society is in a power to compel anybody to prove their ownership. They have a members register, and their job is to simply hand over possession of the vacant flat to the builder from the current list of members, and then pass that possession back to those who vacated the flat. So I don't know what the society thinks of itself, what the managing committee thinks of itself in making people go through these extra hurdles, and clearly they have not sought any legal advice or professional advice in this regard, because whatever advice we received clearly indicated to us that whatever documentation we had given to them, especially the NOCs and the indemnity bond, should be sufficient to participate in the redevelopment process, including signing the developer agreement and permanent alternate accommodation agreement. So, this is the whole purpose of this disclosure. It is to question the society on their locus standi and also their jurisdiction in the legal sense, to put us in a position where they are clearly now going to use the society's resource to fight us before judicial or quasi judicial bodies to determine if my father is the rightful owner to this flat. I believe that the wise members of the community would come forward to support me and use the power of public opinion to question the society. Thank you.